In this lesson, we're continuing our discussion of equal protection. Specifically, we're going to focus on the suspect classifications that are subject to strict scrutiny under the Equal Protection Clause. So from a big picture perspective, if we're looking at a constitutional law fact pattern and we see the government is passing a law or taking some action that treats people differently or unequally based on their membership in some classification. In other words, the government is passing a discriminatory law or taking some other discriminatory action. And we're analyzing that law or that action under the Equal Protection Clause. We know the analysis is going to hinge on the level of scrutiny we're applying. At default, we know we apply rational basis. Rational basis is our default standard of review in equal protection cases. And if we're applying rational basis, we know in most cases the government will prevail, meaning their law or their action will be upheld as constitutional under the equal protection. However, as we move up in the level of review, as we apply heightened levels of scrutiny, as we apply intermediate scrutiny and strict scrutiny, it becomes increasingly difficult for the government to prevail. And we know in most cases, if we're applying strict scrutiny in an equal protection analysis, we know the government is not going to prevail. The law will actually be struck down as unconstitutional in most cases when we're applying our highest level of scrutiny, which is strict scrutiny. So we can see how this analysis, the conclusion of our analysis, really hinges on what level of review are we applying. Are we applying our default level, which is rational basis, where we know it's more likely the government is going to prevail, or are we applying a heightened level of scrutiny where we see it becomes increasingly difficult for the government to prevail? And the way we know in an equal protection analysis what level of scrutiny to apply is by looking at the classification that is involved. Remember, we said at its core, the way we kind of issue spot an equal protection analysis on a constitutional law fact pattern is when the government passes a law or takes some other action that is discriminatory, meaning they're passing a law or taking some action that treats people differently based on their membership in some classification. So what we have to do in an equal protection analysis is look at that classification and ask ourselves, is that classification suspect, quasi-suspect, or some other classification? Because if it's a suspect classification, we're applying strict scrutiny, our highest level of review. If it's a quasi-suspect class, that classification that's involved is quasi-suspect, we're applying intermediate scrutiny. And if it's some other, it's neither a suspect class nor a quasi-suspect class, it's some other class that's being discriminated against, we apply our default standard of review, which is rational basis, okay? So in short, to summarize this, in an equal protection analysis, it hinges on the level of scrutiny we're applying. And the level of scrutiny we're applying depends on the classification that's being discriminated against or is the basis of the discrimination. If it's a suspect class, we're applying strict scrutiny. If it's a quasi-suspect class, we're applying intermediate scrutiny. If it's some other class, it's our default standard rational basis. Okay, that is the equal protection analysis summarized. All right, and so in this lesson, we're really going to focus on the analysis when we're dealing with a suspect classification. We're applying strict scrutiny because the government is discriminating against a suspect class of people. Okay, what does that analysis look like? Well, as kind of from the start, again, as another big picture, generally we have three kind of major suspect classes we need to think about. Three categories the Supreme Court have defined as suspect classes. We have race, national origin, and alienage. These are our big three we want to think about. It is possible you could have more, but for our purposes, we really want to focus on these three: race, national origin, and alienage. Okay, so from a big picture, when the government passes a discriminatory law based on race, national origin, or alienage with the requisite intent to discriminate, and remember we talked about the governmental intent requirement in a prior lesson, the court will subject the law to strict scrutiny, our highest standard of review, to determine whether the law is constitutional under the Equal Protection Clause, even if the law purports to favor a protected class as a means of redressing the effects of past discrimination against the class. This is a really important point we can kind of just give an overview of here. We're going to cover this parenthetical in our next lesson. Okay, but we can kind of give the big picture here. So, it's important to recognize that we kind of have two types of discrimination you can see. We have what is called oftentimes invidious discrimination and what is sometimes called benign discrimination. Invidious discrimination is probably what we most classically think of in our equal protection analysis. This is like Brown v. Board of Education. This is when the government is passing a discriminatory law with the requisite intent to discriminate, and that law is burdening some protected class of people. And usually it's, a minority class of people that have historically been discriminated against. Like, this is invidious. It's bad faith discrimination on the part of the government. This is what we most classically think of. And in those cases, when the government passes a discriminatory law based on race, national origin, or alienage, with the requisite intent to discriminate, remember we covered that in a prior lesson. That's a really important thing to remember here. We're only talking about when the government has the requisite intent to discriminate. Again, that was in a prior lesson. We know in those cases, though, when the government passes a discriminatory law based on race, national origin, alienage, with the requisite intent to discriminate, and that law effectually burdens that protected class, in almost all cases, when we're applying strict scrutiny, that law is going to get struck down in violation of the Equal Protection Clause. Think about strict scrutiny. We know strict scrutiny requires a very high justification for the government. It's the court's way of saying the only way we're going to uphold this law is if you can provide us a very, very compelling justification. And how is the government going to provide a compelling justification when they're intentionally discriminating and placing a burden on a protected class of people that have historically been subjected to discrimination? It's almost impossible that the government's going to be able to provide a justification for doing that. And that's why in almost all cases, those laws will be struck down in violation of the Equal Protection Clause when we're applying strict scrutiny. However, there is a big kind of exception here, and that's when the government is passing a discriminatory law, but it's so-called benign discrimination. Basically, when the law purports to favor or benefit a protected class as a means of redressing the present effects of past discrimination against the class. This would most notably be laws like affirmative action, where we see the government is passing a law that is technically, by its definition, discriminatory. Anytime you treat two classes of people differently based on their membership in a class, even if it's, purporting to favor a protected class, it is, by definition, still technically discriminatory. And that's why in those cases, the court is still going to apply strict scrutiny. The difference is, if the law purports to favor a protected class, we call it benign discrimination. And in those cases, we'll see, even though we're still applying strict scrutiny, and we're going to cover this in our next lesson in more detail, but even though we're applying strict scrutiny, we'll see in those cases, the government can provide sufficient justification, basically, to survive strict scrutiny. where the court is going to say, okay, you're bringing us enough of a compelling justification for us to uphold this law as constitutional under the Equal Protection Clause. Even though we're applying our highest level of scrutiny, we basically think, a law that purports to favor this protected class as a means of redressing or remedying the present effects of past discrimination. Basically, the court is saying that's a compelling justification that could survive strict scrutiny in some cases where we actually will uphold that law as constitutional, even though we're applying our highest level of scrutiny. Okay, and we're going to cover that in way more detail in our next lesson because there's some nuance in that analysis that warrants a separate lesson. So we'll get there in our next lesson. But for now, we can accept that we have basically two categories of discrimination. Basically, invidious discrimination, and that's like Brown v. Board of Education, intentional segregation of schools on the basis of race. That's the bad faith type of discrimination, the intentional, purposeful, with the requisite intent to discriminate, discrimination that is almost never going to be upheld as constitutional when we're applying strict scrutiny, okay? But we do have this idea of benign discrimination. It's not invidious, it's benign. And it purports to favor a protected class. In those cases, we can see we're still applying strict scrutiny, but there is a higher chance the government can prevail and those laws will be upheld as constitutional. And we're going to get into that in more detail in our next lesson. Otherwise, though, that is the big picture, right? So from here, we've basically gone over everything we need to get through a suspect classification analysis under the Equal Protection Clause. We've talked about the requisite intent to discriminate requirement in a prior lesson. We've talked about how to apply strict scrutiny to determine whether a law is constitutional in a prior lesson. Remember, we had that lesson on the judicial standards of review where we talked about all the differences between rational basis, intermediate scrutiny, and strict scrutiny, and we really broke down how to apply those to determine whether a law is constitutional. So we've talked about how to analyze a law under strict scrutiny. We've talked about the governmental intent requirement in equal protection analyses. So, and we know the big picture now of the suspect class analysis. So really all that's left for us to kind of have mastery of this analysis is, well, what makes a classification suspect? We know our big three. We know we have race, national origin, and alienage. When we see the government discriminating based on race, national origin, and alienage, we know that's what triggers the analysis. So there is this idea of the why is that? What makes a classification suspect? And the answer is, while the Supreme Court has not defined concrete requirements, it has stated that suspect classification status is reserved for classes of individuals who exhibit obvious, immutable, or distinguishing characteristics that define them as a discrete group and or are saddled with such disabilities or subjected to such a history of purposeful unequal treatment or relegated to such a position of political powerlessness as to command extraordinary protection from the majoritarian political process. Okay, so I know that's a lot to unpack. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone! My name is Serena, and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva, and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle, and I am a first-year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final, and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.